Hello, I'm attorney Elizabeth Meneray, and I'm coming to you again with another topic from the Rampart Guide, which was produced by the Ella Project and which I was pleased to be a co-author of. And we've been sharing these videos with you to help you learn about the process of identifying and preserving your legacy as a creative person. One thing that I want to talk about today applies to anyone who lives or dies here in Louisiana, whether they have a will or not. And it's an easy way to allow property to pass from one generation to the next without having to go to court, without having to obtain judgments or other impediments to moving forward after a person has died. The trick here, though, is that the succession must be what the law defines as small. A small succession in Louisiana means that you die holding property that's valued at no more than $125,000. Now, I know as of this recording that the legislature is thinking about increasing that level. So you'll want to check, if and when you decide to use this procedure. But right now, we're talking about estates that are valued at $125,000 or lower at the time the person has deceased. And so the portion of the guide that deals with small successions starts on page 59. And so there are forms here that are just like the ones that I use. They may very well even be my forms or some donated by other attorney volunteers to this program. But the point of these forms is that small successions can be accomplished simply by an affidavit that's signed by the closest living relatives of the decedent, preferably a spouse and at least one heir. All of the heirs can sign if that's convenient, but it's not required. Now, I mentioned earlier that you didn't have to have a will to do this type of succession procedure. So this first form on page 59 is called an affidavit of small succession intestate. Intestate means without a testament or without a will. And so if the decedent died without a will and had very little personal property, then his heirs could take care of the estate through filling out a form like this and signing it in front of a notary. And essentially, the law will recognize the passing of this property from one generation to the next simply through this affidavit. I can tell you from personal experience, when my dad died, he had a bank account that had very little money in it. And my sister and I were able to complete this process and take this to the bank. And we each received checks of an equal amount. They did the distribution of the account right there while we waited. So I can tell you from firsthand knowledge that this is a process that works. So as long as the property is of $125,000 in value or less, then this will work. So you would use this to do things like close a bank account, maybe transfer a car, if it's an older car, not worth very much. Maybe obtain small household items or goods of that sort. Although if there's no will, there's really no need for a succession to do that. It's really when you have to deal with a corporation, a bank, an entity that's holding some of this property, and you need to prove that you have a right to obtain it from them. That's really where this sort of comes up. So you'll see that you'll put the name of the deceased person here in the top, and then the parish in which you're executing this before the notary would be here. And here you would put the decedent's name again, where he was born, the last four of his social security number, and when he died, where he died and where his residence was located. Sometimes people may die in a parish outside of where their residence is, and so that's why it's worded that way. You could be a domiciliary of Orleans Parish, say, but maybe have died out at Ochsner in Jefferson Parish, and so you would correctly state that if that's the case. You would say he died without a will and the date of death, to whom he was married, if anyone, how many children there were, and who the affiants are. The affiants are the people who are signing the affidavit. And like I said, that's usually the spouse of the deceased person and at least one of the other heirs. And you'll see that you're signing this under oath, that you're saying, that there are no other heirs, or if there are, you go ahead and you list who they are. And you're saying under oath that the property that belonged to the deceased was his sole and separate property, and it's valued at or less than $125,000. And so you want to list that property here, and an estimated value. And there's a note here that, if the decedent was married at the time of his death, the property he owns is only a one half interest in whatever it is, because of Louisiana community property law. And of course, if you have a prenuptial agreement or matrimonial agreement that made the marriage a separate property regime, and you would know if that was the case, well then, maybe he does own 100% of the asset. But in most cases where there's no prenup or other agreement, a married person is going to die owning one half of certain items. The spouse owns the other half. And so you can't give away or probate what you don't own. So in this case, what you'd be probating is the one half interest in the property, if they're married. Okay, and then we're moving down. And so you see it's as simple as that, but the affiants will sign in front of a notary who will also sign. He'll affix his seal, and then whatever the property is, bank accounts and things of that nature, you can take this affidavit and probate without having to go to court. And on pages 60 and, 61 and 62, no, I'm sorry. Oh, I see. It was above. There was also on pages 55 and 56, an affidavit of small succession testate, which means that there's a will. So in this case, you would fill in the names of the executor according to the will and at least one other heir. And if there aren't any heirs, then you would need someone who had personal knowledge of the facts contained within this affidavit. And then you see it proceeds in the same way that the other one does, with the same sort of information that you would need, except that there's a will and you'll attach the will to the document. And down here at the end, you will list any particular bequests that were made in the will. So if there's certain property, say, the decedent left you his car, then you would list the car. You would include information about the car, especially the VIN number, and to whom it is left, and a rough value of it. And you would go through for each thing listed in the will and list that out. And again, you sign before a notary. And so, I will say that with regard to vehicles, if a person dies and all they have is their old car, certainly no one wants to have to go to the court and pay to file a petition to probate a will that only leaves an old beater car to someone. But, you can't insure it without good title. And so it's one of those things that simply has to be taken care of. This is a cost-effective, easy way to begin the process of transferring the vehicle into your name. Although the DMV may require other documents to be signed. And so you would just have to find out what the requirements are at that time. As far as I know, if there are other family members, other potential heirs to that property, then, they may have to sign another document for the state to release that vehicle just to one of you. So just be aware of that. Generally, though, this is something that can be done very simply, and it does not cost a lot of money. An attorney can prepare this for you, or you can prepare it yourself using these forms and take it to a notary and get it notarized. Thank you for your attention. It's been my pleasure to bring this information to you, and good luck to you.